Hello friends, Patrick McFarland here of the Liberty Weekly podcast, coming at you with episode 114 of the show. And as always, the show notes may be found at libertyweekly.net/14. This one is entitled A Libertarian Theory of Negligence. And I'm going to start off with a few announcements, and these aren't announcements that are not substantive, so just bear with me, I suppose. I got a new position. I left my first firm that I started practicing law at, and I joined another firm. And this has been happening kind of in the background. I don't think that I really officially announced it on the podcast, perhaps in bonus material at some point in time, which you can get by supporting the show at $3 or $5 a month at patreon.com/libertyweekly. So get some bonuses there. We got a real good crew of patrons for the show. A lot of us hang out in the Liberty Weekly Discord channel at libertyweekly.net/discord. And that's a free invite for all you to come and talk. Pete Raymond is in the group, as well as some other podcasters in the community. So there's that. So you can join there. But I have not actually really done a podcast recently that's just been me. The other shows are a little more popular with Keith and with other interviews and stuff like that. So I will be getting into substantive theory here. I haven't really prepared much of anything, so I'm going to be going off the cuff a little bit. There have been a lot of legal issues that I've been wanting to dive into in the past couple weeks here, but I just haven't really had the time to really buckle down and do the reading and research needed. I'm learning a lot of stuff on the job, and frankly, when I get home after thinking all day, the last thing I want to do is think some more. But I am getting back into reading substantive theory more than I did in the last few months. So just a little bit about my new position. It's a really great law firm, very high caliber cases. I'm very blessed to have this opportunity. I'm very excited about it. And my practice area has gone from general practice to more focused on personal injury plaintiffs, so representing people who have been negligently injured. We're going to be talking a bit about that in the show today. Also representing medical malpractice cases, which in Wisconsin are very, very hard to win, but they exist. There were only 77 medical malpractice cases that were filed in Wisconsin in last year. And of those, I think only 3 of them went to trial and the plaintiffs won and recovered. So very hard to prove, and part of that has to do with the lobby in the legislature. There are a lot of special interest groups that lobby, not surprising for us, but I'm still trying to figure out what this means from a libertarian angle, and maybe I'll postulate on that a little bit in this episode. But on the one hand, you want to advocate policy that protects doctors and medical institutions from being sued unjustly. But on the other hand, there is a big argument to be made. You know, on the one hand, you want to protect doctors and other professionals from excessive litigation in which it would make it very hard for them to have a business and run that business effectively. And as we know, as libertarians, serve a whole bunch of people with cheap goods and services. On the other hand, and we'll get into this in the episode, when you have negligence, you put people's property rights at risk. And when you injure someone negligently by unreasonably putting their property interest at risk, justice would require that there be some kind of compensation there for the property that has been lost. And actually, before I forget, there's a video version of this on YouTube. For those of you, I know the vast majority of people do not listen. They don't watch the show on YouTube. They usually listen to the podcast, and that's fine. But the video version, I have a few little... I'm experimenting on OBS software here, so you can see some logos that I put up to make the video look a little more fancy. So medical malpractice, personal injury, products liability, which we can get into a little bit. And I'm also representing civil rights plaintiffs, and mostly in federal Wisconsin, or not Wisconsin, the federal code USC 1983 actions. So that is a smaller chunk of my practice area, but I'm hoping that I'll be able to grow that area within the firm and within my own practice. So this is all from the plaintiff side. So defending people who have, or not defending people, but suing the government and police departments for excessive use of force, violation of civil rights. You can see how that'd be pretty exciting for me and pretty exciting, hopefully pretty exciting for the audience to have someone on our side who is advocating that way. So I'm still, I have one of those cases right now that I'm working on already. So very exciting. I'm very thrilled to be in this position, but this is civil litigation. I'm a trial attorney, and so I'll be taking these cases to trial. Most cases settle out. Mediation has really done a lot for the state system to settle cases, to have cases settle before trial. Mediation is, I believe it's court ordered, where it's basically a guided settlement negotiations where you have both parties go into a given venue, and the parties will be in different rooms, and there's a mediator that kind of runs back and forth to each party and negotiates, and they try and come to a settlement number. It's a little more structured, and frankly, it has a lot to do with the inefficiencies. From my perspective, I believe it would have to do with a lot of the inefficiencies that come with a monopolized state system like this. So that's a little bit of what I've been up to professionally in the sidelines. There will be a day and age when the podcast and my professional career combine more blatantly. For now, I'm kind of shifting from one back and forth. I hope that once my career gets a little more established, that I'll be able, like Stefan Kinsella, to do speaking events and appear on different venues and podcasts and go to PorcFest and stuff like that. So that's a goal that I have in mind. And hopefully I'll be able to publish some serious works in the future. And like I said, I'm still figuring out how to balance those different aspects of my career. But as I'm moving forward here, I think that as I'm standing on more firm ground in terms of my career, I think it'll be a bit easier for me to do that and for me to speak with a bit more authority and clout on these matters. So I'm really looking forward to that. Another note is when I alluded to the fact that I've been thinking a lot more about different legal issues, I got into a YouTube argument on the Dave Smith video, the debate with Professor of Logic Ben Burgess. Maybe I'll put it in the show notes page here. I'm going to have to I don't have a pen. I should make a note to myself to link that in the show notes. But I really didn't feel like I got into an exchange with someone about what the court system would look like, because I implied there's a point in time in which Ben Burgess says that, in the court of Dave, you could haul someone in and then completely destroy them. And then it would be a private court and you could completely destroy them. And how is that for due process? Well, I said that usually in libertarian courts, jurisdiction is based on the consent of the parties beforehand. That's the way it worked in Anglo-Saxon times, and a lot of different systems too. And this guy commented and said, well, how would it work, if one person just refused to consent to the jurisdiction of the court, or if there was a judgment and the court didn't have the coercive power that a state system has today? How would anything work? It'd be chaos, yada, yada, yada. And maybe you could see, I won't list it on the screen here because I don't want to mess with that because I'm live and I don't want to edit. But I gave a whole bunch of examples throughout history in which courts have not had the coercive power of the state, and how courts in the past have still been able to enforce judgments either through other means other than violence and coercion. That would be contracting to jurisdiction before the fact. It could be through the risk, the reputational risk that different businesses would have. It could be through exile, or like in an Amish system, excommunication. It could be the threat of losing your standing in the court itself. So envisioning a system of private courts in which if you refused to submit to the judgment of the court, well then guess what? You can no longer bring actions in this court anymore. That would be a real threat. And moreover, there are systems that have functioned and they have functioned and thrived throughout history. And his objections were, oh, that would require an informed marketplace, and that just doesn't happen because, everyone knows that Nike hires child laborers, and people still buy Nike products, or people buy Ford cars and they explode sometimes, which I didn't think it was a strong objection, but I didn't think I really had a good answer for that. But I just kept reiterating that courts have done this, it's not really a big deal, and he just dismissed them offhand because he doesn't know what alternative dispute resolution is, and the fact that many large companies in the United States will go through a private arbitration system before taking things to court, and this is very common. It's private, it exists today, it functions, and so you could tell that he didn't know what alternative dispute resolution meant. And so he just dismissed all these things offhand, like, oh, well, that only exists. The prevalence of customary legal systems are only prevalent in third world countries or developing countries today. So therefore, I can completely disregard them and how they function, and they legitimately do function because we live, how arrogant is that? We live in this highly complex established society. It's post-industrial, and therefore nothing from the past, nothing that these developing third world countries have found to work applies in this situation. I think that's very small-minded to think that these mechanisms couldn't work when they do. It's pretty... So, but I wasn't very satisfied with my performance there, and I said, hey, this is a waste of time, man. So I didn't plan on addressing that in this episode or in this little chat, but it really made me think, because it made me think that my answers were not adequate enough. And so it's been a while since I've talked about non-state justice systems, and I'll put a link in the show notes page. I think it's libertyweekly.net/36. So I did that episode. Yeah, it is. libertyweekly.net/36. Non-state justice systems, a primer. And in that one, I went through customary legal systems. They exist all throughout the world. The stat that I had is that there was a UK think group, a policy institute, that estimated that throughout developing nations, 80% of cases in those nations are solved through these customary legal systems. And these customary legal systems either have no state involvement, minimal state involvement, or some of them actually, the customary legal system will have the subpoena power, not the subpoena power, the enforcement power of the state. So even though there are private courts, it's a lot like in the United States, there are tribal courts in which Native American communities on certain reservations have their own court with their own rules, their own way of doing things, but their enforcement power is backed up by the U.S. government. So it's a situation, some of these, to be fair, some of these non-state justice systems, customary legal systems throughout the world, have a relationship like that, where they have their own jurisdiction, their own rules and procedures for everything, but the final judgment is backed up by the state in whatever country it is. But a lot of them do not, and a lot of them secure judgment through respect to the community. Go listen to episode 36 to get my take on that. So, but sorry if I'm being long-winded here, but it really, this conversation or argument really made me think that I was not satisfied with the answers that I could give. I still think I'm right. I don't think no matter what I said, I would have convinced this person that I was right, because he had his own preconceived notions. But I'm just trying to drive home the point that this is if you knew about this, you would accept the fact that this does exist, and you can't just ignore it and throw it all away just by saying, oh, I don't know what that is, or therefore this doesn't apply. I mean, these systems, customary systems that don't have state enforcement, they do exist. They have functioned throughout history. I don't have the book in front of me, but I'm reading I'm reading David Friedman's Legal Systems Very Different from Our Own, his new book that's coming out, and he talks about these various enforcement mechanisms. And what I really came to realize through this conversation and this argument and reading the book, because I looked it up, is that a lot of systems, every single enforcement mechanism that exists has pluses and minuses to it. There's no one enforcement mechanism that works better than others. Each one works in its own different area. And when you have a coercive one, the problem is that you end up imprisoning more people than all of the world's prisoners combined, or you end up having, a system that I described too in the small claims court is that there's no way to, if someone sues you and they don't have or if you sue someone and they don't have assets and you do that in small claims court, there's no way to recoup the judgment. It's really hard a lot of the times, because what you can do is put a lien on someone's property, but if they don't have property and they don't care about that, there's nothing really that you can do except hold them in contempt of court, which accrues lots and lots of fines, or put them in a cage, or garnish their wages. But that doesn't always work, because a lot of these people don't have jobs, or they accrue the fines, but they don't have money to pay the fines with, and then even you have to put money up front and have a contempt action and pay for that and pay for an attorney. So I hope you're enjoying this little my stream of consciousness here. We're about 17 or 18 minutes in, and I haven't even talked about negligence yet. So I'm thinking that I'm going to have to spend a lot of time to really think about this and come up with a very structured episode on this question, or write a policy paper or a book or a series of essays about these specific questions and have my own brand and say on it, something that's memorialized a little bit more than just podcast episodes, which, good for some entertainment purposes, doesn't have the staying power of like a paper in the Journal of Libertarian Studies. So plus it would kind of solidify me a little bit as an authority on the subject, perhaps, but it'll take a lot of work and I'll have to do it in my spare time. But I think my ultimate result is, my conclusion would be on this issue, my conclusion is that this is the reason why we can't have one monopoly justice system. We have to have multiple competing justice systems, which is not controversial to us, but to this person that I talked to would be a pretty controversial result. But you can't have one with the coercive monopoly on it. It ends badly. Or at least if you have one that has the coercive power of the court, it would have to be libertarian, you would only have to coercively bring people in if the plaintiff is alleging property violations, property rights, if there's a real damage, which in a libertarian system, I guess you would think that would be every single one. But you'd have to, if you take someone into custody or if it's a civil issue, you would probably have to end up paying attorney's fees if you lost the case. So, and you would have to compensate them for attorney's fees and probably compensate them for the time if you allege property violations and use a coercive power to bring them in no matter what. I'm still kind of thinking about that. But ultimately, you would have to have competing systems of arbitration with different enforcement mechanisms, because each one has its own pitfalls. So the solution would be a free market. Go figure. A free market in different arbitration systems that within them have their own different policies would be the best way to go. And without the coercive system, I guess without a monopoly on the law, you could have a court, and this is what I realized, is that you could have a court that backs things up and subpoenas people in and grabs onto them and puts their hooks into them. It would just be that really easy for them to go bankrupt if they overstep their bounds through the loss of reputation in the community, or basically through the loss, because they don't have the tax cattle that the state does. So they could exercise some muscle to get people in. And I'm just thinking off the top of my head here, but they would have the muscle to bring people in, but if they abuse that power, they don't have the tax cattle to involuntarily suck the funds from. So, sorry about that. On to negligence here. Let's take a look. I brought about an outline here. But this is a section of the civil law that is called torts, and this was one of my favorite subjects in law school. It wasn't my best subject, but it was my favorite. Now I'm a personal injury attorney. So we're going to go like that. Video capture device. Here we are. Okay. Display capture. Torts. This is Black's Law Dictionary. What is a tort? I'll define it for you. See if you can, hopefully you can read that. A tort is a wrong or an injury, the opposite of a right, so called according to Lord Coke, it is. B, because it is wrested or crooked, being contrary to that which is right and straight. So a tort is like a torsion. It's like a crooked thing that you have to set straight. It's kind of like a twist in the law. In modern practice, a tort is constantly used as an English word to denote a wrong or wrongful act for which an action will lie, an action to make it right. The plaintiff brings an action, as distinguished from a contract. So you get remedies in tort that are different than contractual damages. And a lot of times in different actions, like, let's say right now I'm working on a car accident case where our client was hit by someone, and that person didn't have insurance. So our client is suing the insurance company that had a policy with our client. And as part of our claim for uninsured motorist benefits, when you are hit by someone that is not insured, and you have uninsured motorist coverage, you can make a claim to your insurance company. Your insurance company does not always evaluate your claim in good faith. So a problem comes between that. Right? So a problem comes there. Your insurance company that you paid a policy to and you have a contract with did not represent you and fulfill their end of the bargain. Now they're disputing in bad faith the damages that you should be awarded because you had uninsured motorist coverage, you're hit by an uninsured motorist, period. As a part of that, there's a part of Wisconsin law that says, well, are you going to get damages in contract or in tort? Because there's a tort, there's a duty that your insurance company has to you when you hire them. That duty, that's a fiduciary duty of good faith. So in order to bring this action, you have to have both a violation of the contract, the actual policy that you have with your insurance company, and you have to have a violation of that duty of good faith. One is a tort damage and one is a contract damage, because I'll reiterate, I'll say it again. One damage comes from the fine letter words of the policy that you had that were violated, the policy between you and your insurance company, and another damage comes from the fiduciary duty, the tort duty that the insurance company had with you of good faith and fair dealing. So to go back to what a tort is, just after distinguishing the difference between a tort damage and a contractual damage, a tort is a legal wrong committed upon the person or property independent of contract. It may be either 1, a direct invasion of some legal right of the individual, 2, the infraction of some public duty by which special damages accrue to the individual, or 3, the violation of some private obligation by which like damage accrues to the individual. In the former case, no special damage is necessary to entitle the party to recover. In the two latter cases, such damage is necessary. So I'll include a link to this definition of what a tort is. Really interesting stuff here, guys. It really is. I'm being sarcastic, but I'm not, because this stuff is really interesting. So part of what tort law is, we see negligence. The law of negligence is very wide, or the concept, the theory of negligence is very, very wide and far-reaching. It encapsulates a lot of different scenarios, as opposed to an intentional tort like battery or assault or false imprisonment or severe infliction or intentional infliction of severe emotional distress. That's a really fun one that's really hard to prove. But negligence is its own thing, and it's maybe, I don't know, 3/5 of your entire L1 torts class. But going back, I picked this outline just off the internet somewhere. I'll put a link in the show notes page so you can download it if you'd like and follow along. You'll see it's a little outdated. It's from fall 2006. But the overlying policy justifications for tort law, according to this outline, and this is what they'll teach you in law school, maybe not always correct, or from, the standpoint of us libertarians. Corrective justice or fairness is a goal of tort law. The defendant is responsible for repairing wrongs to the plaintiff. Of course, as a libertarian, this would be violations of contractual obligations. And pairing back to the libertarian theory of contract, I believe libertyweekly.net/88, Stefan Kinsella's paper based on the Rothbard-Evers theory of contract, you can only contract, the only upholdable contracts are those pledges of alienable property. So in tort, it'd be damages to personal property. You can get into dignitary harms, which would be libel and slander, which also follows under tort. But I would argue that maybe, and Walter Block would probably argue, that dignitary harms like that, they're not alienable. Well, it's not an alienable property. Your reputation is not property. So that would throw out those dignitary harms. So your primary concern with tort law is compensation, which is compensating injured victims, focused on the harm to victims needing compensation. That's pretty redundant, Mr. Outline here. Yeah, so those are other policy considerations here. These are different torts. Intentional torts, physical harms, trespass to person, a battery. This is real basic L1 stuff here, what you'll probably learn in your first semester of law school. Trespass to land, trespass to chattels, emotional and dignitary harms, throw that in the toilet where it belongs. Unless you can prove that because of the harm that someone did to you, you suffered like PTSD and had to accrue doctor's bills. Those are compensable damages. False imprisonment, someone taking away your liberty, locking you in a cage. Intentional infliction of emotional distress, that would cause you to incur damages. Your psyche is damaged. Interesting property conversation we could have there. This is considered a new age tort. So, and in order to recover for an intentional infliction of severe emotional distress, someone has to go beyond the bounds of decency, beyond like really ridiculous, so terrible an act and unreasonable that no able-bodied man should be expected to overcome it, is the one of the standards. That's like a quote from a case, maybe this one. But negligence, first off, there's this concept of prima facie elements, and when it's a fancy Latin legal term. Prima facie just means in order to make your case, you have to prove these elements: duty, breach, causation, and damages. That's the rule of thumb. So let's do the restatement for negligence, and then I'll go through and define each element. Duty, breach, causation, and harm is what I learned. Harm. So the restatement for negligence is Negligence is engaging, quote, in conduct which falls below the standard established by law for the protection of others against unreasonable risk of harm. An actor is negligent in engaging in conduct if the actor does not exercise reasonable care under all circumstances. Primary factors to consider in ascertaining whether conduct lacks reasonable care are the foreseeable likelihood that it will result in harm, the foreseeable severity of the harm that may ensue, and the burden that would be borne by the actor and others if the actor takes precautions that eliminate or reduce the possibility of harm. So, I would justify, let's see if I can, I would justify, on libertarian grounds, I would justify the theory of negligence, because only in situations in which you unreasonably put the property of another person in harm's way. That's a good way to sum it up in libertarian terms. The unreasonableness is an objective standard. So you would think of, a lot of people mention the reasonably prudent person standard. So the way to think of it, and this is, I'm already framing what a duty is. So I'll put this on the screen here. A duty is what a reasonable person would do. So if one causes injury to another, his negligence is judged by the standard of care, which is usually exercised by the ordinary prudent man. And I think this might be Oliver Wendell Holmes that they're referring to in this outline, who famously said that, 3 generations of imbeciles is enough in the Buck v. Bell case. Forced sterilization during the Progressive Era. Holmes argues that the courts must set an objective standard of care. If every person is to act, they need to know what the standard is in order to base their actions. Quote, the law considers what would be blameworthy in the average man, the man of ordinary intelligence and prudence, and determines liability by that. Holmes does note that some exception exists, which is blindness or insanity. So if you're, I don't know, I think they're referring to, if you're blind, the standard would be, what would a reasonably prudent blind man do in that condition? That would be it. So here's a case that they're discussing, Robert v. Ring. This is not one that I studied in law school. But it was, the defendant was an elderly man who, 77 years old, who had a loss of hearing and thereby ran over a 7-year-old boy who jumped in front of his car. The law rejects a subjective standard of taking into account the defendant's age and holds the man liable so that he will be forced to take additional care considering his infirmities. So it's not, in this situation, it's demonstrating the fact that the law would not consider what would a reasonably prudent person do. There's an increased burden of care for a deaf man who undertakes driving a car. Therefore, the duty would be higher, because if you're a deaf person driving a car, you would think that a prudent person who is deaf would take extra precautions not to cause an accident if they decided to drive. The law does not hold the child liable because he exercised the reasonable standard of care of a child. So we're really kind of getting in the nitty-gritty here. I think that you could probably understand just from this what a duty is, what a standard of care is. So let's see here. So moving on, you could really talk into, and these articulates all the nuances of what standard of care would apply in specific cases, different types of defendants, what the duty might be. So I'm not going to get into the hand formula because that's a really complicated topic that could take an entire episode, but basically the formula is there's a duty of care to protect others from the harm when the burden of taking adequate care is less than the product of the probability of the resulting harm and the loss of that harm. If the burden is less than the probability of harm, so this is positivism at its finest here. Empiricism at its finest is trying to have some kind of and this is a progressive era thing, is having some kind of empirical formula that you can put together to calculate what the what the standard of care would be for certain instances, instead of taking things, while trying to frame things in a case-by-case basis by plugging it into a formula. And this is Judge Learned Hand. I believe he was on the Supreme Court, but progressive era. I mean, it sounds like a positivist progressive era kind of thing. Let's see. Yeah, you can define reasonable care through industry customs. That's another way you could do that. Here's medical malpractice custom. And so the lobby gets in, the doctor's lobby, physician's lobby gets in and really messes with this a lot of the time. They will change the standard of care through fiat, through an act of the legislature, which is abominable. It should be set through jurisprudence and the common law. Other ways to establish negligence is that you can prove that someone acted below the standard of care by introducing evidence that they violated some kind of a rule, whether it be a policy, an internal policy of the defendant or other companies around the defendant, or you could prove that they violated some kind of a law. A lot of cases, like pretty much one of my cases I had in law school for a simulated court trial that I won handsomely, by the way. I got six-figure judgment in this case. Too bad it wasn't real. But there was evidence that my client was hit by someone. Their car was hit by someone in this fake case, and the defendant wanted to introduce evidence that I was parked illegally, so that I was violating some kind of a law, that my client was violating some kind of law, was parked illegally. Or, I don't know, if someone was cited, sorry about this. So a lot of times, this is called negligence per se. So if I'm suing someone for a car accident and my client, the plaintiff, was hit by another person's car, I would try to introduce evidence that the other person was speeding, because, and if after the fact, if the police officer who responds to the accident will issue a citation to the plaintiff saying that they were speeding, that really helps me out, because I can introduce evidence of that citation to say, look, he fell below the standard of care because he was speeding. That's basically what it is. You fell below the standard of care because you violated the law, and because you violated that law means that you were not, I mean, it's per se, by definition, you were falling below the duty of care because we established these laws as a duty of care from a policy standpoint. So going back, I don't know when this outline is going to hit. Causation, here we go. So causation. So you need to illustrate there's duty, breach, causation, harm. We already went through breach. I was kind of talking about how you could illustrate a breach of that duty, saying that someone falls below the standard of care. The next element is causation. And there's different causation tests, because sometimes you get into, well, there were multiple things that went wrong here in this series of events. And a good defense, I mean, from the defense standpoint, you disprove any one element of these four elements, duty, breach, causation, harm, and you win the case. It's a little bit of an uphill battle for the plaintiff, but so a lot of times your best defense would be picking apart at one of the elements, because the other elements may not be disputed. But you could dispute, causation, right? I'm just trying to think of a quick scenario. In medical malpractice cases, there's a lot of contributing factors to the death of the plaintiff. Say it's like a wrongful death in a medical malpractice case. There could be competing causes of death. Well, he didn't die because we left a sponge in him after the operation. He died because he had, lung cancer, and it was really advanced. So the lung cancer killed him. It wasn't us leaving a sponge in him. And here it comes, the cause and fact causation. You can see on the screen, but for causation test. But for us leaving the sponge in the plaintiff, would he have died? Would be the question. Well, no. If the answer is no, then he would not have died but for the sponge. Well, actually, that would be, sorry, the plaintiff. He would not have died but for the sponge being left in him, would be the argument from the plaintiff's side. But for the sponge being left in him, he would have stayed alive. If we can prove that, then we can prove that this injury was caused by the defendant. So that's easy. That's easy to do when there's, I don't know, one like more clear paths to what the causation is. There's another test which is, you have to prove, but for the cause in fact. So you have to prove that that the negligent act caused the injury. You have to prove that. You have to also prove the proximate cause. So there's like sub-elements to the causation. You have to prove but for causation, and you have to also prove proximate cause. You have to prove that this was a foreseeable damage that would have happened from the defendant's conduct. So you have to prove that it actually caused it through the but for causation or the contributing factor test. I forget the actual term for that test. But you also have to prove that it was foreseeable. And this is, you'll get into when it comes to the proximate cause, there's a really famous case with a clock tower and it's Palsgraf. So the Palsgraf test has to do with a passenger who was trying to board a moving train. The guards tried to help the person. Oh, I thought this had to do with the clock tower. But from what I remember, the Palsgraf test has to do with foreseeability. I might be wrong about that. It's been a long time since I've looked at this, but the Palsgraf test was very famous. But from what I remember, I'm really reaching back here. You can read the facts. It was really interesting. But it has to do with foreseeability, basically, this case does. It was an interesting type of harm. I'll just read this here for you. Palsgraf v. Long Island Railroad. So there was a passenger who was trying to board a moving train. The guards tried to help the person, but in trying to help the person board the train, the guards caused his package containing fireworks to explode. So guy is carrying fireworks. He tries to hop on the moving train. Guards go to help him, but cause the package containing the fireworks that he was holding to explode. Yes, okay, this is it. This is what I remembered. The package of fireworks explodes, which causes a scale to fall on a woman standing some distance away from the train platform. And Palsgraf, the plaintiff, represented the woman who was crushed by the scale because the fireworks exploded. So you have to see that the explosion would be a foreseeable result of what the falling below the standard of care, the negligent act, was. In this case, causing the scale to fall on the woman, I believe this was the holding of the case. They decided that this type of harm was too far removed from what you would expect the damage to be. So you would think that trying to help someone get on a moving train, or someone who was carrying a package of fireworks, you wouldn't particularly foresee the fireworks exploding and causing a scale to fall on someone. You could maybe foresee the fireworks exploding and blowing someone up. But as we can see here, this was against the railroad company because the guards tried to help this person running for the train. So yeah, this is another substantial factor test. So to recap, you need both the proximate cause and the cause in fact, in order to prove the element of causation, because remember we have duty, breach, causation, and harm, while they're sub-elements to the element of causation. You have to prove the cause in fact, you have to prove the proximate cause. An alternative to proving the cause in fact would be this substantial factor test. When there are multiple competing causes of the harm, then you get into these different ways of proving the substantial factor test. Which one was a substantial factor? Which one of these many different competing causes was the substantial factor? Because it's not always as easy as saying, but for X happening. So I hope that makes sense to you. I'm really packaging an entire semester's worth of information into one short, in quotations, short podcast episode. So there's different defenses to negligence, but there's contributory negligence, which would say that this was also caused by the negligence of the plaintiff themselves, so therefore I shouldn't be on the hook for this, because yeah, I was negligent and my negligence did cause the harm that the plaintiff suffered, but the plaintiff was also negligent, guys. And if you're trying this in front of a jury, oftentimes the jury will award percentage points to what the plaintiff is asking. And you could even have counterclaims. So the plaintiff sues a defendant for damages, and say it's a car accident in which both the plaintiff and the defendant are hurt. Well, you could have and usually this would be on behalf of insurance companies, but you could have the plaintiff suing the defendant, and then the defendant also suffered injuries from this crash, and the defendant could in turn also sue the plaintiff for the injuries incurred. This would be contributory negligence. Competing themes of negligence. So I mean, there's a bunch of other stuff that we could dive into, but I did causation, I did breach, falling below the standard of care, and I did duty, and the last one is harm. And just proving that all those things caused harm to the defendant. So in a nutshell, I mean, I just really kind of went through everything for the most part, that you can get like a bird's eye view of it. So you can check out the rest of this outline. I probably won't do a deep dive into it. You can see the scroll bar on the right hand side. There's a whole bunch more. There's the issue of strict liability, but just in terms of negligence, I mean, that's a lot of what I'm dealing with too, in my practice. So I'm just scrolling here for those watching the video. So these are the four elements I went over: duty, breach, causation, harm. And like I said, I think Libertarian, you can get into the nitty-gritty of what Libertarianism would have to say about this, about each specific application of the theory of negligence. But fundamentally, I do believe that the theory of negligence is very libertarian. It is backed up. If you put someone else's property in harm's way and a damage results, you went below the standard of care that we would expect in our society of people acting reasonably, then I think you should be on the hook for compensating those people. You destroyed their property, and you did so unreasonably. So I think that puts a good bookend on it. I hope that you enjoyed this episode. Sorry if it took a while to get strictly to the topic of negligence. I worry about that a little bit, but I think I do like to keep the audience up to date with what's going on with me, and usually I try and keep that to the end of the episode. But for this one, it was important enough news to move to the front of the episode. So, and also just talking about, where the podcast is at and how that's all going. So as we're closing up here, a lot of the regular plugs that we go through. You can find this podcast at libertyweekly.net. You can also support the show and get access to great bonus content by going to patreon.com/libertyweekly. I am still waiting for Jordan Peterson and Dave Rubin to come out with their alternative to Patreon. I'm just so established on Patreon now that... Oh, I also have, Bitbacker, which is libertyweekly.net/Bitbacker, where you can donate to the show with cryptocurrencies and get access to those same tiered bonuses. I don't have them all listed now because no one has yet pledged on Bitbacker. But at that point, once I get a pledge there, I'll start cross-posting all the bonuses. And there's hundreds of bonuses going back a couple years that you get access to on Patreon. So go check that out. I mean, I'll put it on screen. Patreon.com/Liberty Weekly. Now that I'm going through in the video version of the show. Shout out to my 10 patrons, which you can interact with a lot of us on Discord, libertyweekly.net/Discord. But you can see behind the scene a little bit here. Here's full unedited access to my interview that I did with Actual Anarchy. I reviewed My Cousin Vinny, and this 3-hour chunk has me going through in detail listing trial tactics and going through and examining the trial in detail and pontificating in that way. And here's access to the video version of that. You get all 3 hours of access, uncut, unedited. I do Patreon bonus episodes. I reviewed, and here's the video of it, I reviewed a whole long conversation that I had with someone on Facebook. An argument trying to convince them through the candles in the dark method of voluntarism. And here's an interview we did with James Corbett. This was early access. You get early access and stuff like that too, so you can see all of these bonuses. And I can scroll down. Here's a Spin Master Patrick. I did an hour of DJing where I spun some of my vinyl records that you can get access to. Oh, and this was an episode that was going to be aired that was canceled that I put in the Patreon group. It's a whole episode with Keith Knight that we did. Oh, maybe I didn't cancel that. I might have canceled that episode. I'm not quite sure. Is that episode 106? Oh, man. I've been posting a lot of stuff. Oh, I just renamed it. I thought about canceling it. Sorry, Keith. So yeah, there's more bonus content. I won't beat a dead horse here, but there's a whole bunch of stuff. So go check that out. Also join the Liberty Weekly email list at libertyweekly.net/email, or you can go to this email list sign up in the horizontal menu bar at libertyweekly.net. Also the Amazon affiliate link at libertyweekly.net/Amazon. Go do your regular Amazon shopping. At no extra cost to you, we'll get a kickback, which I use to buy books and other equipment for the show. Otherwise, there's also Liberty Weekly merch store that you can go on Zazzle and get Liberty Weekly products that I designed when the show first came out. Check out this coffee mug. I mean, I did really like this coffee mug that we did. So go check that out. It has the vintage throwback logo on it, which I could update, I suppose. But yeah, it looks really nice, I think. Otherwise, there is a t-shirt that I made at Teespring of Murray Rothbard, and I did a polygon design on it. I think it's teespring.com/Murray Rothbard. So you go that. Yes, this is it here. I think it's beautiful. It took me forever to do this polygon design with Rothbard and his little bow tie that you see. And I put a great quote on the back. And I get a lot of kickback from this merch. You can get it in sweatshirt format in a whole shitload of colors. You can even get a cup with that Murray Rothbard polygons design on it. It looks really sharp and really modern. So check that out. That's at teespring.com/Murray Rothbard. All one word, of course. Anything else I'm forgetting here? My apologies. I don't think so. Amazon affiliate link. Yeah. Okay. And you can donate directly through PayPal, which the button is on the right-hand side at libertyweekly.net. So thanks so much, everybody, for bearing with me. I hope I didn't ramble too much about, what's going on with my life and the professional transition that I'm going through and all that stuff. So I eyes towards the future here a little bit. So once again, show notes page at libertyweekly.net/114. Thanks so much for joining me. I really appreciate it. Take care.